si waongozi wazuri, lakini mimi ningependa kusema contradict wewe mwandishi wa habari hivi. Gachagua amekuwa impeached na Senate na akawa impeached na bunge, lakini kwa saa hii Deputy President, in case Ruto resign ama chochote kifanyike, mwenye ata assume office si mwingine bado ni Gachagua. Kwa hivyo Gachagua bado ni Deputy President wa nchi mpaka process zote ziishe. Sasa kichungo cha mwisho kenye tumengoja kumaliza, kile sasa cha kumaliza ni mambo ya koti. Kwa hivyo mkondo wa sheria ufuatwe na wampe haki yake. Kama ni Kithure Kindiki wampatie haki yake, lakini sione Kithure Kindiki, hata yeye ni profesa anafundisha mambo ya law, anajua tu, lakini sasa ni kutumia thorax, kwa sababu ni kama sasa Abomination Act. Yani wewe ni waziri wa usalama, unanyang'anya mwenzako polisi ili wewe uchukue nafasi, wakiona aibu juzi wakamrekesha. That is very wrong. Hata ulimwengu pia inaona hiyo. Kwa hivyo mimi naona ya kwamba jambo la Kindiki haliwezekani kwa sababu IBC haiko in the place. BBI ilianguka kwa sababu ya mambo ya IBC. Sasa kama IBC haiko elective and a very big post kama ya Kindiki, lazima IBC itangaze, ipeleke process zote, lakini na nikutumia kifua na mambo yenye rais amefanya yote, koti imetupa tanga ingie uongozini. Ningeomba tu rais atumie sheria ili kutulinda sisi na kufanya nini? Kufanya maendeleo. Sio kila kitu anafanya kando kando alafu koti inatupa.
Na je, pengine unahisi kwamba wanasiasa ama viongozi humu nchini wameweza kulegea kidogo, kwa sababu kuna baadhi wa Kenya pengine wanahisi kwamba pengine priority ama ingekuwa lengo lao kuu lingekuwa kuangazia kuweza kuteua tume hiyo, kwa sababu ni ya dharura sana, ikizingatiwa kwamba kuna hata baadhi ya maeneo bunge katika ukanda huu wa Pwani hawana usimamizi katika bunge la kitaifa kwa kukosa tume hiyo ya IEBC.
Ni surudia
na kuona kana kwamba wanasiasa wamepoteza mwelekeo.
Hapo inaonyesha wazi ya kwamba wanasiasa wamepoteza mwelekeo. Kwa sababu gani? Wakati walikuwa wanaangazia mambo ya kuimpeach Gachagua, hawakutaja, si kuona umetaja mahali popote mambo ya IBC. Na mambo ya IBC inatakana iwe in place. Hata mambo ya Kindiki ndio itafanya vizuri. Mambo ya wale wenye walikufa ama wenye walitoka uongozini iende sawa sawa. Hawajongelee hiyo hata kidogo, wameweka kando. Saa hii sasa ambapo mimi nasema viongozi wote wamepoteza, yani hawana ile fikra za kuona hii nyumba isianguke, ikae hivi na tuweke ile beam ya kushikilia kwa vitengo zote kama IBC iwe pale. Sasa wao wanacheza kama hao na hawajui IBC kule inatakana pia icheze kama IBC ambapo haiko. Kwa hivyo ni makosa process yote ya kutoa huyu Deputy President mpaka kufika mahali wanasema wanataka muondoe.
Asante. Mwisho kabisa, tayari tumemwona Rigathi Gachagua ameelekea katika mahakama ya rufaa. Je, pengine unahisi kwamba kama mkazi shughuli hii nzima ama mchakato huu mzima wa mahakama huenda ikachukua muda zaidi, na pengine iwapo kama uamuzi utakosa kutolewa leo na mahakama kwamba nafasi hiyo ya naibu rais iweze kuteuliwa ama iweze kupewa mtu kushikilia ambaye ni Kithure Kindiki ambaye tayari ameshateuliwa, wana pengine kwamba shughuli hii nzima, mchakato mzima wa mahakama hasa umekuwa vipi tangu kuanza na jinsi ambavyo tunavyoelekea, ikizingatiwa kwamba Rigathi Gachagua kwa sasa yuko katika mahakama ya rufaa?
Mimi kwa jina anaitwa Martin Wambua. Mimi nikiongelea katika
tazame kwenye kamera.
Mimi nikiongelea katika hii mchakato wa Gachagua na Kindiki, tukiangalia from the beginning, tunajua impeachment ya Gachagua haikufanyika kihalali kuanzia mpaka National Parliament mpaka Senate. Tunaona ile vitu ambayo ilitumika pale, na sisi wa Kenya tunaelewa kila kitu yote bila inaendelea. Sasa kama pile jinsi ambavyo umeongea hii kitu, mwanzo ingekuwa rais wetu angekuwa saizi tafuta chairman wa IBC, sababu hiyo vitu yote hakuna kitu yote ambayo inashughulika pale. Wao wanataka wao tu ndio wanashughulika kila kitu pale ambapo haki haipatikani. Sasa mimi kitu ambacho naweza ongelea ni mambo ya Kindiki. Mimi siwezi kukubaliana naye kwa sababu saizi tunatambua kama Rigathi Gachagua as our Deputy President of Kenya, kwa sababu yeye mwenyewe mwanzo anjatolewa na ninio na kesi iko mahakamani. Ile nyingine ambayo ningeongelea ni katika hao majaji ambao walikuwa wanaambiwa 3 ambao wanaambiwa wako na dosari katika hii kesi ya ninio. Na tunaona vizuri kabisa wale lawyers washaona kiini cha kile ninio. Sababu hata unajua hata wewe saa hii upelewe kotini ujue judge ameongwa pesa, hakuna vile utaweza kubali aendelee na kesi yako. Kwa hivyo mimi ningeomba hata hawa majaji pia wafuate haki ili Gachagua pate kuonekana.
Asante. Well, indeed, Michelle, those are quite mixed reactions from the residents of Mombasa. And as we wait for the happenings to begin at the court, the High Court in Nairobi, we will definitely be on standby to collect most sentiments from the residents of this county, including the leadership, to bring you up to speed on what they expect from the court, and of course also collect the views after the proceedings at the court on what they'll have to say about it as well. Back to you, Michelle.
That is Kevin Mutai live for us from Mombasa. Very mixed and emotive reactions there from Kenyans on the ground with regard to the impeachment case against Dp.Gachagua. And of course, at 10 a.m. we're counting down minutes to the resumption of the hearing of that case by the 3 judges of the High Court. And this even as the impeached deputy president, of course, moves to the Court of Appeal seeking to stop the proceedings before the High Court, pending the hearing and determination. The 3 judges last week refused to recuse themselves from the case, as well as ruled that they were properly empaneled by the Deputy Chief Justice. Now, Gachagua's lawyers have termed that decision by the 3-judge bench as a grave misinterpretation of Article 165(4) of the Constitution, and also say it was a wrong analysis of the letter and the spirit of the Constitution. We have live pictures for you there from the courts as lawyers and the different teams prepare for the resumption of that case. Now, in the ruling that last week, the 3-judge bench, they are led by Eric Ogola, Anthony Mrima, and Dr. Frida Mugambi, had ruled that the constitutional mandate exercised by the Chief Justice in that Article 165(4) of the Constitution is an administrative function, and that the Deputy Chief Justice can then handle the same function in the absence of the Chief Justice to ensure that constitutional responsibilities are carried out seamlessly without disruption. Gachagua's team, they're saying that is a misinterpretation of the spirit and the letter of the Constitution, but all indications are that the hearing will take place before the 3-judge bench, which essentially could render as useless that appeal by Gachagua's team before the Court of Appeal. And so we keep our eyes on that case. We'd also like to hear your thoughts and views on this ongoing process. Do speak to us at NTV Kenya on all our social media channels. We'll be sampling your thoughts and comments in the course of this live broadcast. In the studio with us, political analyst Sandra Njoki and lawyers Jared Mugendi and Joshua Nyamori. Jared, we are seeing preparations there in the court, a clear indication that the hearing then is likely to resume before the 3-judge bench. What implication will this have, one, on the appeal by Gachagua in the Court of Appeal, and on the final decision of this 3-judge bench, which Gachagua's team has termed as an impugned bench already?
Hey, some of those words that they are using are quite interesting. And I think my learned senior will agree with me. There is no advocate who is trained to go combat mode in courts. You are always taught to be respectful, because no matter how emotive blind the basis for recusal, they have said if you have a proper basis, if you have propriety in what you are saying as a bench, we should recuse yourself. Advance those without fear, but they must be founded. And they have outlined it clearly. Connections such as I attended someone's wedding, and I was just showing Sandra a few minutes ago, in one of the paragraphs, the judges is saying, Justice Mrima was awarded an award at Nairobi International Show by the then His Excellency Deputy President Dp.Gachagua. So why is that not bias. If you can take a photo from 3 years ago, you don't show the connection with the current issues at play, and that is not bias. So you can also see the restraint that the bench has. Like Milimani colleague said, the bench will continue as long as there is no order to prevent them from proceeding, because they have work to do. And I am not really sure what they will attempt to do at the Court of Appeal that they have not achieved here. If the evidence that they tabled is what they are going to go with, you know, an appellate court reserves the trier of facts, that is the initial court, some discretion. What they observed you in court, they were able to see how you are interrogating your case, how you the witnesses, how they were responding to the questions put of the courts below. So I am not very confident that going to the Court of Appeal will be their saving grace if we have interacted with the evidence that they have and it is falling short of the standards that are required. Because just before I conclude, the test that they were advancing of a fair-minded person, that fair-minded person is not the litigant, because the litigant has a stake in the case. So it cannot be the fair-minded person that the standard of recusal is talking about. It is someone completely far removed from the case at hand.
All right. Nyamori, Gachagua's lawyers have further taken issue with the judges for declining to extend the interim order that essentially was blocking the replacement of Gachagua with Kithure Kindiki. The order itself lapsed on the 24th of October. What implication does the lapsing of that order have when the judges hear this case or resume hearing of this case today?
Yeah, one, I think that the lawyers of the Deputy President are clutching on straws. There is really no implication on the lapse of that order, because there were two orders, and the second order that is still subsisting was more enduring than that order that has elapsed, because that order that had elapsed was stopping Parliament from receiving nomination by the President. But as we were informed, it was served after this had happened and the name had been approved by Parliament and gazetted. But the second order which is subsisting is an order which prevents the deputy, the nominee who has been approved by Parliament from being appointed and from assuming office. And I think the court did not interfere with that. Application to lift the order should be a response on the application for conservatory order. It is important. There is a statement that the judges made that probably has not been picked by the public, that they take note that the Kerugoya order was a final conservatory order and that they did not interfere with it, and they're wondering why the petitioners were not complaining about that. Some of us from the bar hold that that order was irregular. Irregular because normally when giving injunctive or conservatory orders at ex parte level, courts do not give final orders. They give interim orders. And interim orders are given subject to subsequent, hearings, or for a period of time, normally not more than 2 weeks. If you read the limb 5 of the Kerugoya order, it simply gave a blanket conservatory order. I believe that that is one of the things that are going to be discussed, litigated today, and I think the court left it for both parties to argue it before they make a decision on it. My hunch is that they are going to decide that it was given irregularly and that it should have been an interim order. But at the same time, there are decided cases which speak to the order being lifted today.
All right, let me just interrupt you, Nyamori, for a second and take us live to the courts with the session just about to begin. Our reporter David Muthoka is inside the court to follow up on these proceedings. Muthoka, thank you for joining us. What do we expect for the better part of the day?
Well, Michelle, any moment from now, we expect the three-judge bench of Eric Ogola, Freda Mugambi, and Anthony Mrima to make its way here and begin hearing an application that was filed by the Office of the Attorney General. Now, AG Dorcas Oduor wants this court to lift orders that bar Interior CS Professor Kithure Kindiki from taking the oath of office in a swearing-in ceremony and assuming the office of the Deputy President. So basically today, we expect that three-judge bench to hear that application that will, of course, be made by the Office of the Attorney General, that is represented by former Attorney General Professor Githu Muigai, as well as other lawyers from that side. But of course, we expect rejoinders from the side of impeached Deputy President Rigathi Gachagua, who is seeking to have those interim orders that prevent Kithure Kindiki from succeeding him extended. So indeed, today, it is another week and another day of a legal showdown here at courtroom number 18 at the Milimani Law Courts, as we expect to see that hearing almost take an entire day, as well as a ruling that could come later in the day or tomorrow, where Professor Kithure Kindiki will know his fate. Now, this particular hearing is taking place at a time when an appeal has been made at the Court of Appeal by Rigathi Gachagua's side. And in that appeal that was satisfied as urgent, the side of the impeached Deputy President wanted this hearing today suspended until the appeal is heard and determined. Rigathi Gachagua's side in that appeal is saying that the empanelment of this bench was not done in accordance with the law, saying it ought to have been done by Chief Justice Martha Koome, whereas it was done, and that is Anthony Mrima, where Rigathi Gachagua's side said that he has a close association with the Speaker of the Senate, Amason, to the board of the Kenya Water Towers Agency by former Environment CS Soipantuya on behalf of President Ruto. And this comes at a time when it is said that the falling out and the breaking of relations between President Ruto and Rigathi Gachagua actually was a catalyst to Gachagua's ouster from his position. So we expect that appeal to be heard at a later date, and that means that this particular hearing now will be taking place, and indeed we expect various lawyers are presenting various petitions here. Indeed, as we expect the three-judge bench to make its way, actually just sitting just a few meters from where I'm standing. Already the courtroom is packed. This particular side is filled with various lawyers, including Professor Tom Ojenda. I'm also able to spot Githu Muigai. I'm also able to spot Tharaka MP Tonga Murugara, as well as Solicitor General Kennedy Mose. While on this other side, I'm able to spot Gachagua's lawyers, and that includes Paul Moitem. I'm also able to see Ndegwa Njiru and Ad ready to present their various applications and petitions before the three-judge bench. So now it is a matter of when, not if, this.
Of the resumption of the hearing of the case against impeached Deputy President Rigathi Gachagua. Top of the agenda, as Muthoka tells us, there is the hearing of the application by the Attorney General as well as the National Assembly to lift orders options barring the swearing in of Kithure Kindiki as Gachagua's replacement. I have a panelists here in studio who have been putting it all into context for us. And it's clear that the court session is just about to begin. Let's begin with our final comments as we also, take a look at the likely proceedings of the day. So Nyamori, I cut you short. Let me just give you a chance to finish your thoughts as well as your expectations as to how that application seeking, the swearing, to clear way for the swearing in of Kithure Kindiki is likely to go in light of the other consolidated cases that are challenging the impeachment of Rigathi Gachagua already.
Yeah. When Rigathi Gachagua's supporters speaking about this matter, they seem to argue that the court should sustain the conservatory orders because they feel that Rigathi Gachagua is injured as an individual. While I'll align with court judgments, especially if I go back to the Munya case, which was touching on the impeachment of the former governor and former CS when he was Governor Munya, where the court that conservatory orders are not like injunctions which deal with private interests and rights of individuals, and therefore where whether that are linked to the prospects of irreparable loss or are linked to the likelihoods of success. Here we are dealing with a public law issue, and it is to be decided on the inherent merit of the case itself, bearing in mind the public interests, bearing in mind also the constitutional values, and also bearing in mind the proportionate magnitude of the matter and the priority levels attributable to the relevant cause. Right. In my view, when you look at...
I am very sorry to have to cut you short again. The court process has over and listen in live.
His Lordship Justice Eric Ogola, presiding judge. His Lordship Justice Anthony Mrima, Her Ladyship Justice Dr. Frida Mugambi, for hearing of application on petition E565 of 2024 and E522 of 2024.
I guess we have taken the quorum.
Yes, my lord, the court assistant circulated a list and we all put in our names.
Is there any preliminary issue before we proceed? We have received a letter through the office of the Deputy Registrar that the 9th respondent intends to provide video evidence. We mentioned this because so that to let you know that we received that letter, but at the same time, I think this court is properly moved, not by way of a letter, but by way of an application. and therefore the advocate for the 9th respondent will treat that as just a letter.
My Lords, the only preliminary issue that I can think of is allocation of time.
Yes, Council, we are doing right that. This is how we will proceed with the hearing of the application. Yes, Council.
My Lords, your leadership on Friday, when the court gave directions on how to proceed. As my Lord the presiding judge observed, perhaps all of us had been working very hard the previous day. So the court left rather quickly when I was on my feet. And I was standing up to draw this Honorable Court's attention to the fact that no directions had been issued in respect of an application which is on record, which is a contempt application in the Kerugoya matter, where the judge, your brother, in the Kerugoya matter, directed that because of the urgency of the matter, and that he had referred the file to the Chief Justice, that application for contempt, which was on record, would be argued before the bench to be constituted by the Chief Justice. So that application continues to be on its hearing and disposal, because as we all know, a contempt ordinarily is not permitted audience before purging the contempt. Can we have your directions for that contempt application to be heard and determined? I thank you.
What is the date of the application?
Muge, where are these people with the consent? You need to use this.
My lady and my lords, my name is Muge for the third petitioner. Now, my lady, that contempt application is dated 9th October 2024.
Thank you. Now, this is how we will proceed in the matter. The matter is coming up today for hearing of the application, that is application for conservatory orders and the one to set aside. We gave directions last week. We will proceed with those applications. At the end of the hearing of those applications today, we will give directions on the hearing of the application for contempt. So for purposes of going forward, those petitioners who file applications for conservatory orders, will regard them as the applicants, and each of them will have 15 minutes. If there will be need for more time, we will consider as and when. And then any party in support of the application for interim reliefs will have 5 minutes each. Respondents, who are the applicants in the applications to set aside, will each have 10 minutes. And those in support will have 5 minutes. And then the applicants will have 10 minutes each in rejoinder. Interested parties, will give them 5 minutes each. And if Senior Counsel Mr. Dr. Amino is around, we will consider his plea.
My Lord,
my Lord, if I may pray, that in view of your directions in regard to the contempt application, we would like it placed on record. In view of the holding in the Supreme Court case of Republic versus Ahmad, Abolathi Mohammed and another, that any application for contempt, just like a preliminary objection, should be heard before any other matters. In view of that holding, my lords, we would like that placed on record that you have decided that we hear the potential contemners before the court in the face of that contempt application.
My Lord, I think the court has given a direction, and our position on that is that if counsel is unhappy with the directions you've just given, he knows what to do. We have spent far too much time running away from the business of the day. This matter was certified urgent several days ago. It seems on the 9th of October that when the applications before you were certified urgent, we came here, the other side scattered the date when we came with what turned out to be a frivolous issues about to empanelment. When sufficient time had been wasted on that, they came again with what turned out to be a frivolous application on recusal. Now you're being told about the application for contempt. We must take it as beyond argument that when this application came before the court in Kerugoya, whereas the court in Kerugoya fixed a date for the application now before you, it did not fix a date for the application. Now you're being told to jump the queue. And if that be the case, then we must take it. It did not impress the court in Kirinyaga as an application warranting the type of priority that you're now being told. On the issue of whether contempt, if that argument were to hold, my Lord, we too, the party representatives, filed a PO, and you've not heard me telling you that that PO should start. I'm just following the directions being given by the court. And when all is said and done, my Lord, the Swahili say, akili ni nywele, kila mtu akona zake. Nobody needs a brain in this court to know that the reason for all this dilatory tactics is because this side believes having obtained